The Supreme Court heard oral arguments today in Gill v. Whitford, which could be the first broad constitutional judgment on gerrymandering, the practice of redrawing voting districts for political gain. In Gill, the court looked at a voter redistricting plan devised by Republican state legislators in Wisconsin in 2011, which paved the way for a GOP sweep of the state's government. This past May, the court found splitting votes along racial lines violates the Equal Protection Clause, but has previously refused to issue opinions on gerrymandering more broadly, in part because it can be difficult to prove. Jennings v. Rodriguez was also argued today, after being rolled over from last term so the justices could rehear it with Neil Gorsuch to round out the bench. Alejandro Rodriguez, the lead plaintiff, was born in Mexico but grew up in the U.S. as a permanent legal resident. After he was charged with drug possession, the Department of Homeland Security detained and tried to deport him to his birth country. Rodriguez fought the deportation and was eventually released, but not before spending 3 years locked up. Rodriguez is fighting the U.S. government in a class action suit for immigrants to get regular bail hearings when they're locked up long term. The government argues that immigrants have no right to bail and can be held indefinitely. And they often are. The plaintiffs in this case were detained on average for more than 400 days. Gorsuch's first full term will be packed with cases that could reshape American law. Here are some others to keep an eye on. David Patchak, a property owner in rural Michigan, was unhappy about the federal government's decision to place an area of land near his house into trust for the local Native American Gun Lake tribe, which later built a casino. Patchak challenged the Interior Department's authority to take land for the tribe. Congress responded by banning any legal challenge related to the property. At question in Patchak v. Zinke, which will be heard in November, is whether Congress overstepped the limits of its power by barring Patchak's lawsuit. The decision could affect Congress's ability to protect Native American land from political and environmental threats, like the Dakota Access Pipeline. When Timothy Carpenter was a suspect in a Detroit robbery investigation in 2011, cops tracked his every move for months using location data from his cell phone company. They didn't get a warrant, but they didn't need to. Cell site records aren't protected by the Fourth Amendment because users voluntarily submit the information to a third party, the service provider. But Carpenter v. U.S. asks whether these types of searches are actually constitutional. The case will likely have a huge impact on how the Fourth Amendment gets applied to the role of metadata in technology surveillance. Arguments haven't been scheduled. There's also no date scheduled for perhaps the most awaited case of the term, Masterpiece Cake Shop v. Colorado Civil Rights Commission. It involves a bakery in Colorado that violated a state civil rights ordinance by refusing on religious grounds to bake a wedding cake for a gay couple. The cake shop claims that its refusal is protected by the First Amendment. The Trump administration filed a brief supporting the bakers in early September. The decision could establish a precedent that religious belief creates an exception to civil rights law. Or the justices could take a more narrow approach and just decide whether cakes constitute a form of free speech.